This is Kelly from Watch the Obsession. Thanks for taking time to watch this video.
There are more answers than you know.
I'd like to take a moment to thank all of the channel members. I appreciate you guys so much. If you'd like to become a channel member, the link is below. And to everyone in the live chat tonight or watching the replay, thank you so much for your support.
Each had multiple stab wounds. Some had defensive wounds, showing they fought with the attacker. And there was no sexual assault. County Coroner Kathy Mabbutt is describing the murders as personal.
All right, welcome everybody to Watch the Obsession True Crime, and it is Friday night, WTO, Watch the Obsession Date Night. So I am so glad that you guys are here for the live chat. Welcome everybody, come on in. Hope you can participate in the discussion. We just, of course, ask that you are respectful to the victims, to their family members, and of course, to one another. So everybody come on in and feel free to share your opinions. So warning label Nina is going to join me in just a little bit. I just want to talk about a couple things first, and then I know that she'll have a lot to add to the discussion and add herself because she is really good at researching this information as soon as it comes out and making some sense of it and adding some insight to it. So if you haven't checked out her channel yet, again, it's warning label Nina, and she's going to be coming up in just a little bit. So hi, Nina. Thank you for everything. So we are going to be talking about the unsealed transcript. This is one of the things we're talking about. There's been a whole lot of new information coming forth in the Idaho versus Bryan Kohberger document dump. So you can just go to that website, Idaho Cases of Interest, and right there you're going to have a list of all of the filings, the orders, the documents, the attorney's motions, the judge's response, and in that you can glean a little bit of information about the evidence in the case that we don't know too much about due to that really broad and really strict gag order. But recently, since we've had a switch from judge to Judge Hippler, that air of secrecy is sort of dissipating over this case. And some of the secrets are definitely being revealed, and it is so super interesting. I think it's kind of good that that's happening. That just started randomly playing. I think it's kind of good that's happening. Imagine if they just waited to disclose everything at trial and we didn't find out anything. We would just all be in an overload, right? You know what I'm saying? So one of the things I want to talk about as we're watching tonight is kind of like Bryan Kohberger's playbook. In the recent unsealed transcript of the January 23rd and 24 hearings and the other documents that have dropped, we have three different ideas of what Bryan Kohberger might try to use in his defense. 1, an alibi, and that's a little iffy, right? 2, alternate suspect theory. And then 3, autism. Apparently, he's on the autism spectrum, which doesn't surprise me. Now, for those of you who don't know, I was a special educator for a long time, and I'm a behavioral therapist now. So, working with mostly teenagers who are on the autism spectrum and being part of that diagnostic process, of course, I can't do certain things, certain doctors or therapists with certain levels of certifications, psychiatrists will, sometimes actually make the diagnosis, but I know all about autism spectrum just by virtue of my career. And it doesn't surprise me to know that he is or might be on the autism spectrum, but we're going to talk about whether or not that is a legitimate offense. So I want to go back in time a little bit. So this and look at some of the sort of moves that have been in Bryan Kohberger's playbook, Bryan Kohberger and Ann Taylor's defense playbook all along. So I'm just going to bring something into the stream here. We're going to get warmed up and check it out. And then we're going to get into those recent docs and bring Nina up. Nope, is this it? Yeah. And this also connects with the roommates, Bethany Funk and Dylan Mortensen, as everything does. It's going to in trial, trust me.
Kelly from Watts the Obsession. Thanks for taking time to watch this video.
The surviving roommates, Bethany Funk, appear in court in June to testify at Bryan Kohberger's preliminary
Taking time to watch this video. Please click like and subscribe and hit the bell for future notifications.
In the documents obtained by Fox News, the subpoena demands one of the surviving roommates, Bethany Funk, appear in court in June to testify at Bryan Kohberger's preliminary hearing. This is not the roommate who witnessed a masked man in their home the morning 4 of her friends were murdered, but a second roommate who told police she was in the basement at the time and never went upstairs.
After the channel's most recent live stream, I was thinking about this. The amount of information that the defense team, Bryan Kohberger's defense team, led by Ann Taylor, has managed to get out to the public, to the masses, to potential jurors in the midst of a strict and broad gag order that has been in effect since January 5th, 2023. Before we get into the rest of this video, I just want to acknowledge the victims and their families. The victims, Kelly Gonsalves, Madison Mogan, Ethan Chapin, and Xana Granodal. May we find justice for them and peace for the families.
And then I was also thinking about this, which is a statement I read a couple times during the live stream that is from the defense's objection to the state's motion for a protective order regarding some of the DNA evidence, and particularly the investigative genealogy DNA evidence. So the statement reads, no matter what came first, the car or genetic genealogy, the investigation has provided precious little. There is no connection between Mr. Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's car, office, apartment, home, or vehicle. So what exactly does that mean? When I first read that statement, or when I was first thinking about that statement, I was wondering, oh my gosh, does that mean that there is literally no evidence from the victims in Kohberger's apartment, office, car, or his space anywhere that they have investigated? But then I thought about the show that the defense has been putting on ever since the pretrial proceedings for this case have started. And that is, of course, as far as we know, because many people close to this case are under that broad and very strict gag order. So let's think about one of the first times that we heard from the defense in a big way and a way that made headlines. And that was the defense's motion to compel Bethany Funk to testify at the pre-trial hearing. So what was the defense's reason for compelling her to testify in that pre-trial hearing? Well, according to what they had to say, it was because Bethany Funk had exculpatory evidence that could, well, by the definition of exculpatory evidence, they're saying that could exonerate Bryan Kohberger. Exculpatory evidence is evidence that shows that somebody is not guilty of the crime for which they are charged. So let's go ahead and take a look at that motion to compel Bethany Funk's testimony at the pre-trial hearing and see exactly what we're going to move forward through that because we all know what it says.
Making that statement at that time. So what exactly could this exculpatory evidence be that the defense is continuing to allude to? Now, understand that the defense is under ethical guidelines that, according to the oath that they've taken to be an officer of the law, to be a member of the American Bar Association, they can't just throw out statements that are baseless, that don't have any foundation in fact or any kind of evidence that they are aware of. So for the defense to say that they believe that a certain witness has exculpatory evidence, it's under the scrutiny of the court eventually, if they choose for it to be under their scrutiny, to test the validity of the statement, at least the knowledge that the defense attorney had in making that statement at that time. So Ann Taylor is well aware that she is representing a defendant in a very high profile case, and she has an exceptional trial record history, which is one reason she is a defense attorney for Bryan Kohberger. So unless she's going to put everything on the line, unless she's going to put this trial on the line and her career as an attorney on the line, we have to believe that Ann Taylor has a good faith reason to assert that she believes Bethany Funk might have, or she's.
You know what? I'm getting impatient with this after DB Tape just told me about that new document that just dropped because I've been refreshing it all along. So I'm just want to blow through this.
Case.
So where does that leave us as far as what the defense has been doing with the amount of information that they have gotten out to the public and therefore potential jurors in the midst of a strict and broad gag order?
Now, why this is important and relevant to what we're talking about tonight is because this is critical to my understanding of like all the defense's filings and everything that went on in the January 24th and 23rd hearing and everything that is still going on. This is a defense's playbook, the way that they're getting information out to the public or in to the case that might not otherwise be allowed in very strategic and sneaky ways. I mean, Ann Taylor is doing her job. She's doing what she has to do. Oh my God, he's facing the death penalty. She has to defend him zealously. That is what we do in this country. So I don't know if sneaky is the right word. Clever. It's clever.
Starting with claiming that Bethany Funk has exculpatory evidence proving that Bryan Kohberger may not be guilty after all. And then extending into all of the evidence that the defense has requested through 4 different motions and supplemental motions and amended motions from the state that so far, I guess we know that the state has not given them everything that they want because they wouldn't continue to make these motions if they had everything that they had asked for. At some point, it would become redundant. It would become pointless. The court would be like, no, this isn't legitimate. And there would be an end put to it because these are professionals at work that we are observing. Based on what we understand about the ethical and moral obligations of.
Okay, you know what? I'm just going to stop that. So the point of this here is, because we're going to talk about the alibi tonight. That's one of the 3 A's. So there's like 3 A's that are the possible Bryan Kohberger defenses at this point. There's the alternative suspect, there's the alibi, and now we have the autism Asperger spectrum. So that's actually kind of 4 A's, but it's 3 different items. So the whole point, I believe, with the motion to compel Bethany Funk, because she has, there's an experience of her own, and she knows things, she heard things, she saw things that are nobody else did, that it's unique and it's materially the case. I think, and particularly with what I know about what Bethany Funk's experience was now from the inside sources that the channel has to the case, the two students who are friends of Ethan Chapin, I think that the reason the defense wanted to do that was because they were still crafting Bryan Kohberger's alibi, because I'm not so sure that he legitimately has one. We're going to speak to that today when we look at the current documents. So it is my belief that the big wild card in their mind, what they were most afraid of is, oh my God, what is Bethany going to say? We know so much about what Dylan's going to say. She was interviewed 4 or 5 times. She, what she said was more extensive. It was more precise. It was more specific. She saw the assailant up closer and from a front view, whereas Bethany saw him further away when he was outside, from the back and from the side. So I think they were really nervous about that. So they have been trying to get as much information as they can. They've been trying to see as many of the state's cards in their hand, so to speak, before they even dared to put out that theory of an alibi, which was never really a well-developed, complete theory of an alibi. And as we all know, it was submitted extremely late. Now, the important thing here is these are the games that the defense and Bryan Kohberger are still playing with us. So let's take a look. But before we do that, let's take a look at the document that DB Tabin, welcome DB Tabin, everyone else, come on in. So glad you guys are here. Just made me aware of. I've been looking at these documents and reading them all day long. I'm refreshing. And this one just dropped. And I'm going to say, folks, it's disappointing. So thanks to DB Tabe, we now know this. Just going to pull it up and read it to y'all. So this document just came out. Have you seen this one yet? Warning label, Nina. And I'm going to put the link for you, Nina, in chat right now. Had you seen this yet, Nina? Oh, you had? Okay. It's new to me. All right. So here we go. So this just fresh off the press on the Idaho Court Cases of Interest website and released to the public for public consumption. All right, so this says, so this just came out today, just a little while ago, and this is from Judge Hippler. I was just so excited about all the information that we have found out because there's not that really suffocating gag order in place right now. Well, I don't know. Are things going to change? You tell me. So this is an order for temporary sealing, February 24th, 2025 filings. Well, luckily we grabbed copies of all of those. So that's awesome. But what does this mean for the future of court filings, right? All filings not released by the court for public dissemination made by the parties in this matter on February 24th, 2025 shall be temporarily sealed pursuant to Idaho Court Administrative Rule, pending this court's determinations on whether sealing is appropriate. It is so ordered. So we need a lawyer. Is there a lawyer in the house? So is this just a technicality, or is there, for some reason, a change of heart in Judge Hippler? Some kind of fallout that happened from opening up more information and courtrooms and documents related to this case, or I'm really just not too sure what to make about this. But I'm going to bring up warning label Nina, so we're going to see what she thinks. Hey, Nina, what do you think about this one?
It's sealed.
Well, what do you think that means?
Well, I mean, they really didn't seal anything because they haven't really. All we have is what they put on the summary. As far as the striking the death penalty and stuff.
Right.
They haven't released the documents yet.
Right. Okay.
So, I mean, I don't know. From what I've researched on and you're the expert on autism, but I mean, I can understand that being sealed.
Oh yeah, I think so too. I mean, if even for a couple of things, privacy regulations, HIPAA purposes, things like that. Now, if it is a person's choice, let out that information. That's one thing. If you're fighting for your life in a court case, and this is a critical part, material part of your defense, that's a whole different animal. But okay, so that's interesting. Okay, so the scope of this order temporarily sealing the filings is limited to February 24th, 2025. Okay, DB tape, I almost had a heart attack there. So that's just a couple of things. So that isn't, that isn't all of the filings that were released to the
Well,
public.
she just put in the comments that everything on the page is sealed, is locked now.
Well, I know here. You know what? I'm not going to refresh this page because I'm going to make sure I have everything downloaded first, which I think I do. So everything prior to the 24th DB tape, is that what you're saying?
I'm looking. I'm pulling mine up because I was trying to get to the transcript.
I have the I have the stuff that we were talking about earlier.
No, the transcript came up, so it's not sealed.
Okay. So that's good. So maybe it is just the stuff on the 24th. All right. Okay. All right. So let's get into some of the recent documents that have dropped. And we're going to look at a little bit on the sealed transcript, the unsealed transcript. I don't want to go over the whole thing. It's 175 pages, and there is a lot of back and forth about a topic I think a lot of us are getting kind of tired of, and that is IgG or forensic IgG. And it's just a lot of IgG. We love you, CC Moore, but this is just getting crazy. I mean, there's interesting, but there's also a few other things, a limited number of other things in there that are very interesting. So we're going to, but first I want to look at the filing about the alibi. So let me just get that up. Oh, it's alternative. Oh, let's see. Okay. Let's see. I'm coming, guys. I'm just getting the right information up here for you. There's so many documents, which I love, which we love. Please, Judge, allow there to be so many documents. We don't want them to go away. Okay, so right now we are going to look at some information. Whoops, that says autism defense. Alternative suspect. Alibi. Does Bryan Kohberger have one? And I mean, this really is the question. I mean, regardless of what he puts forth as his primary alibi, his like the fundamental defense, it really sort of does boil down to this question, don't you think, Nina?
Yeah, but if he's sticking with his regular alibi, then there's going to be a little problem with that.
Oh, there is, because his alibi, as we are, and Sherry, thank you so much for the $20 super chat. I appreciate the heck out of you. Welcome. I'm so glad you're here. And hey, John McSmith and Pepper Bewitched. And let me see who else just came into chat. DB Tabe almost gave me a heart attack, but I'm so glad you're here. It's great to see you. Welcome, guys, and thank you for being here. So his alibi isn't really an alibi. It does not satisfy the requirements of an alibi. An alibi is saying where you were specifically during at what time or time ranges, and who is the witness who can support the fact that you were there. He doesn't really have any of those. He definitely doesn't have a witness. He has a very vast, non-specific time range, and he doesn't even really have a whereabouts. Like some state park is mentioned, but it's kind of like, in that general area, basically driving around in my car on the roads anywhere but 1122 King Road. That really is not an alibi, but let's see what the state had to say about that. Alibi.
I have to say that I agree with a lot of the things that are in this, but I can also see where it's causing some the other side to be able to say, see, they don't want it in there because, blah, blah, blah. And I'll continue that when we read some more. But some of the wording, it's like, see there, they don't want it in there because of this. And I'm like, no, that's not what it says.
Well, let's just see what the let's see what the state's motion in limine for the alibi for the alibi. So I'm just going to read exactly what it says instead of putting my own words there. Let me just make this a little bigger. I'm just going to make this a little smaller. Oop, that don't work though. All right, that's fine for now, I guess. Okay. So we have comes now the state of Idaho by and through Lettow County prosecuting attorney and respectfully moves the court in limine for an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, because remember, Ann Taylor said in a previous hearing a while ago with Judge that they were going to establish his alibi through their own expert, or I'm sorry, not their own expert, but through cross-examination of the state's experts. So since they don't have their own witness to put on the stand to support Bryan Kohberger's alibi, Ann Taylor said the way that we're going to establish his alibi is through cross-examination of the state's witnesses. So they say, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. By the way of background, the state refers to the court to the following: the state's May 23rd, 2023 request for discovery disclosure, alibi demand, the state's 2023 motion to compel notice of defense of alibi, or alternatively, to bar certain evidence, and then there's an objection to the state's motion to compel. Okay, now attached are the transcripts from partial transcripts of a hearing that was held on August 8th. And I actually have that video so we can listen to it instead of just read it. And then they have some scheduling orders. And then a big thing is they're referring to on February 23rd, 2024, an order for setting deadlines and hearings, which in paragraph 1 sets an alibi compliance deadline of April 17th, 2024. And that's talked about in the little video excerpt that we're going to listen to. And it was Judge who was presiding. Okay, so now the state says it has now been approximately 20 months since the state first made its request for discovery disclosure alibi on May 23rd, 2022. As the court file reflects, highlighted by the above items, the defendant has failed to comply with the requirements of Idaho Code. The defendant has yet to specify the specific place at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi, as directed by the February 23rd, 2024 order setting deadlines and hearing. As discussed in the state's April 2024 response to notice of defendant's supplemental response to the state's alibi, the defendant proffered April 17th, 2024, a notice of the defendant's supplemental response to the state's alibi demand. And it doesn't comply, the state says. Sorry, got excited there. It doesn't comply with the requirements, with the penal code requirements, or with the specific directive of a court's directive, setting deadlines and hearing. Consequently, the defendant should be prohibited from presenting any evidence, whether by direct or cross-examination, Ann Taylor, you hear that, in support of any claimed alibi other than from the defendant himself. So they're saying, no, you're not going to bring in this BS alibi that doesn't meet the requirements of an alibi because you have no witnesses of your own. You're not going to bring it in through cross-examining our experts, as you said way back in the day with Judge. It ain't happening. The state is saying you are not going to sneak that in this way. Ann Taylor, we read your playbook. We know what you're doing. We live it every day. The only way that we want to hear about an alibi is from Bryan Kohberger himself. So what would that mean? That would mean that Bryan Kohberger would need to take the stand. What would that mean? That would open the door for anything that's already in fair game for cross-examination by the state. Does Bryan Kohberger want to go there? I don't know. And we'll talk about that after. Don't let me forget that question. Even were the defendant to attempt to comply at this late point in time, the state is irrevocably prejudiced. And now it's been over 2 years since the homicides occurred, since the defendant was charged, and it would be unrealistic at this late date to expect the state to effectively investigate and respond to any new or additional alibi-related disclosures. Well, maybe that's exactly what the defense wants, waiving my right to a speedy trial. Over time, memories facts and evidence fade, dissolve, get lost, and are destroyed, right? This is precisely the situation that caused concern for Idaho Court of Appeals, and there's some cases cited here. And the result of those cases, one, was that the Supreme Court held the adversary system of trial is hardly an end in itself. It is not yet a poker game in which players enjoy an absolute right to always conceal their cards until played. We find ample room in that system, at least as far as due process is concerned, which is designed to enhance the search for truth in the criminal trial by ensuring both the defendant and the state ample opportunity to investigate certain facts crucial to the determination of guilt or innocence. So what the state is saying here is, dude, it's been 2 years. Memories fade, evidence gets ruined, gets destroyed, just goes away, blows away, gets dissolved in the wind, turns into dust. It's 2 years later. How the hell are we supposed to investigate this so-called alibi that Bryan Kohberger and his defense have been creating along the way as they've learned things? Now I'm adding my own opinion there, but that's what I'm hearing here from the state. For this reason, the court should issue an order prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, you hear that, Ann Taylor, in support of any claimed alibi other than from the defendant himself. Bitch, get on the stand, right? So, let's see. And then there's a transcript of the hearing that we're just going to listen to rather than read that transcript. So what do you say, Nina?
I totally agree with it. I mean, it's been 2 years. I mean, I don't see how anybody could expect them to come back now and be able to accept it without it coming strictly from him.
Crazy, right. Yeah, I mean, he's already conceded, or the defense, Bryan Kohberger through his defense, has already conceded that there are no viable witnesses, right? So,
well, I mean, in the beginning, I understood the concept of, okay, he was in the car alone. So the only way that we can prove his alibi is maybe on cross-examination of, say, Brett Payne or somebody like that, But after 2 years,
yeah,
no.
We're saying no. We're saying no to that. And then here, let's hear a little bit of the exchange between Ann Taylor and Judge, again, from way back in the day. Where'd that go? Well, here, talk about something else for a minute. I took down the video. I got to open it back up.
Well, congratulations to Deb Tabes. She just became a member from Pepper.
Oh, thank you. Thank you, darling. So happy to have you, Deb. So, I mean, what do you think? Here's a question for you, Nina, while I look for this, and everybody else in chat, we'll highlight some responses there. Do you think that Bryan Kohberger and Ann Taylor have explicitly discussed where he was at the time in question?
Oh, I think she knows everything.
You think she knows? Or do you think it was just like a conversation, with Ann Taylor? I mean, I think, there are, depending on your jurisdiction, and then, federally, there are some rules about, obviously the ethics of practicing as attorney, what you kind of can and can't know and still defend or prosecute someone, right? So, I'm wondering if she does know everything, or if she kind of, from the beginning had kind of a leading conversation with him, something like, so maybe you're going to tell me where you were at the time of the crime, assuming you weren't committing the crime, right? But, maybe, there's reasons, that you won't. And I mean, do you think she really wanted to know?
Well, the thing about it is there's an interview that I think it was Fry did. And he made the statement that it was his car and he was in the car alone.
Okay.
The only way they're going to know that he was alone is if they have some kind of camera showing that he was alone.
Right. But even if he was alone, so what? I mean, he was.
But what I'm saying is, if she has seen that, she knows.
She's seen what?
I mean, with her being the defense attorney, she has seen all the evidence.
Right.
So she knows what they have on him.
Right.
So
Okay.
he can say, no, I was over there stargazing at Wawa Park. And she's going to be going, yeah, really? Well, you see this video right here of you in the car 2 blocks over from the house? We might want to, and I'm just saying 2 blocks over.
Okay, that's right. That's right. Okay, because we believe from what we understand of the state's evidence, there is so much evidence incriminating him of this crime, and particularly being in proximity to the location the crime was committed. It would be, even if she plays that game with him, like she plays a public and she kind of plays a judge, but maybe rightfully so, with her little Ann Taylor playbook, for her to even pretend she doesn't know that if he is kind of absurd.
Well, I mean,
Right.
he might have been trying to play her, no, I was over here stargazing, and her be like, you might want to go look at that video again. Don't try to play the player.
Right. Exactly. Oh, that's kind of interesting. What are people in chat saying?
Oh, they are. Let's see. Oh, we got more. You got more memberships.
Oh, great. Awesome. Welcome, y'all.
Yeah, memberships from Sherry. Thank you, Sherry.
Thank you, Sherry. And gifted membership, right?
Yes, she gifted 5.
She's so sweet. Oh, thank you. 5 new members. That's probably everyone in chat right now is not a member just about. That's awesome. Congratulations, guys. Make sure to thank Sherry. She's wonderful.
And so now everybody's thanking her and everything, and they're like, John McSmith says he's a manipulator.
He is a manipulator. Oh my gosh, absolutely. I think so. Here, let's bring the hearing in. All right.
Yes, of course. You all give me deadlines. I'll write them down.
Thank you, Your Honor. There's been an ongoing discussion beginning most recently with the state's request for scheduling order, and I believe Ms. Taylor briefly addressed it at the last hearing. There's been an ongoing discussion about the alibi deadline, and the state is asking the court to either limit the defendant to presenting evidence about the disclosure that he made related to the alibi, which was that he was driving around the night of the homicides, but not allowing any further discussion or evidence of an alibi, given the amount of time that has passed since the state requested that alibi disclosure. Alternatively, since it was in the court's scheduling order initially prior to the trial getting vacated, we would ask the court to set a 10-day deadline now, because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to the jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there has been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure. And when you look at cases.
Do you remember when she said that? I'm sorry. The defense is considering calling upwards of 400 witnesses during the innocence phase. I was like, say what? Do y'all remember that? That is insane.
Lord, girl, you don't.
Each side.
You don't remember the 400 witnesses? That's how it came out, that they watched it live on their telephones.
I remember that. I'm just highlighting it. Like, damn, wasn't that crazy when we learned this? I mean, the things that came out in this hearing is just like insane. But
you have to admit, she is fantastic at saying what she wants to get out there.
Right.
In a way that it doesn't, I mean, she's really good.
She is. Yes, she is. Yeah, she definitely is. She's doing her job, that's for sure. So here, I'm going to continue. So listen carefully to this, because this gives us really great context about how this whole conversation back and forth between the sides and the presiding judge went down regarding alibi.
Bill Thompson and
sorry, guys. Let's see, it should be right about here.
Okay. We would ask the court to set a 10-day deadline now, because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to the jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there has been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure. And when you look at cases regarding appeals from issues that arise during alibis that come up at trial, these cases are all defendants appealing a conviction because the state doesn't get a second chance. If the state gets ambushed at trial, that's it for us. We're asking the court to hold the defendant to a fair alibi deadline, and I think that the time has come. Thank you, Your Honor.
My understanding was that was it, but I may be wrong. Ms. Taylor.
No. When the court vacated the trial setting, the court vacated all of the deadlines, including the alibi deadline. That wasn't carved out as one that was still held through when the court vacated the rest of its scheduling order. So I don't think that we're foreclosed from that. The court also has the ability to give an extension besides the limited time by statute. In this case, it's more than Bryan was just driving around. We have let the state and the court know that we expect that will be supported by expert testimony and by cross-examination of the state's experts. I need their full cap.
There you go. She said it right there. We expect that will be established by expert testimony and cross-examination of the state's experts. So this motion from the defense is speaking directly to her statement right there. No, it's not going to come out through your direct questioning. It's not going to come out through cross-examination like you said way back when. If you want to establish his alibi, the proper way to do it at this point is to have Kohberger get his burger butt up on the stand himself, and that opens him up to a whole lot.
Past report and the rest of the discovery related to that before I can say more about that. So to tie me to a deadline.
Once again, she says, I need to see the cast report, which is, I think, going to be one of the biggest pieces of incriminating inculpatory evidence that is put forth by the state in this case. I need to see the cast report and something else before I can say anything more about that, right? And they were already way past, even when, the state of Idaho statute says you're supposed to put forth your theory, your statement of an alibi. But she's like, no. We need to wait for the results of the cast report. I needed to hear Bethany Funk's what her testimony is going to be. We compelled her. Now we've got to wait for Cass. I want you to put all your cards right on the table, face up, and then I'll tell you what I came up with, So this has been, you got to connect the dots here.
Fine. When I don't have the rest of the discovery that I've been waiting for that would relate to that, will mean that I will be back asking the court to reopen it. My expert can't finish until I get the rest of the discovery as well.
And the discovery you're talking about is a video of the car?
No, I am.
What do you?
So the video that we talk about is one that I think the state's going to use in its case that I don't have full video on, that I'm not talking about any video of Bryan's car. When I'm talking about an alibi defense, unless there's video that shows it elsewhere that I haven't gotten to yet, which may be possible given the fact that there's a lot I haven't seen yet. What I'm talking about though is the cast report, the drive testing information.
Cast report meaning the identification of the particular car.
That is the cell tower information.
I'm with you.
So
Judge.
What that is going to show and what the drive testing data is going to show and what other reports related to that are going to be things that my expert needs to finish our investigation and things that I need to formulate my cross-examination against the state's expert. So when I'm telling you that I'm going.
Yeah, lady, but listen, it doesn't mean you need all of that to tell the court and the state what the hell Bryan Kohberger's alibi was. This right here, the reason I wanted to play this is so important in my mind is this tells me everything I need to know about Bryan Kohberger's alibi. He don't have one. What do you think, Nina?
100, 100. That was so funny. You're like, you don't have one.
I mean, yeah. I mean, if they, at this time, I mean, this was like almost a year and a half after he was charged. You know, if he had an alibi at that point, you know, what's the problem here? You know, what, you know, you need to find the cast report. What was he with one of the cast agents? I don't know. Like this, it doesn't make any sense.
But
You know?
see, the thing about it too is, okay, this is before was it September the 6th that they did get the cast report, and now she's trying to get it thrown out.
Right. Because she didn't like it. She didn't like, obviously, that's a really great point. So she was waiting for the cast report so we can put forth our statement of an alibi. Then it actually comes out. She was like, oh, they're taking too long. And then she sees it and she's like, oh, shit. We got to get rid of this.
I mean, and then it ends up in the, you know, and all the suppression stuff. Well, why are you trying to suppress it if that's what you were waiting on? And where is Mr. Cyray? Because if you'll remember, Mr. Cyray reserved his right to make a judgment when the cast report and all that comes in.
Right. Right. So, yeah. So, and Taylor, we know, we got your game. We know what's up with that. So, yeah, very interesting. Very, very interesting. So, let's see. What do you guys in chat think about the idea of Bryan Kohberger's alibi? Do you think I know that's what I'm going to put up for a poll. Do you think that Bryan Kohberger actually has an alibi? I mean, this is going to go right along hand in hand with, you know, is he guilty? But I really want to see what you guys have to say about this. I'm going to put up as a poll really quick. And let's see. Does Bryan Kohberger have an...
And now, didn't her other death penalty case start like this month?
I don't know anything about it.
Oh, okay.
Her other death penalty case? You can do two at once? I'm surprised about that.
Yeah, she's doing the Aryan Brotherhood guy that escaped from jail in Idaho. And they went and killed a couple of people. And,
wow.
You know, they're the ones that other create. No, never mind.
Wow. Okay. Yeah, let's not talk about that because people just get Does Bryan go? I don't know why it's not letting me do a poll. I don't know. Okay, fine. It's fine. We're not going to do the poll then. All right. So, you know, that's that with the alibi. Let me see what you guys are saying in chat here. And welcome to you guys coming in. So glad you guys are here. Take a moment to hit like and please join the conversation. If you're new to the channel, please let us know where you're from or what you're most interested about relating to this case. PKC says her newest client is and looks a lot scarier than Bryan Kohberger. She must have nerves of steel. Wow, I'm surprised that they can have two death penalty cases at once. Cuffy says, y'all, I'm telling you, Watch the Obsession has the best live chats as any other channel I watch. And I'm not just saying that. We all know each other. We pay attention to each other and the knowledge base is strong. Yeah, that's right. And if you're new, don't be intimidated. Everyone here is really friendly. We just keep it like that because life is too short. We can't be assholes to each other. BK is creepy looking. Giovanni's Pikachu and welcome. I'm glad you're here. Let's see. And thank you for Honeybond gifted 5 memberships. Thank you so much. And Cherry also gifted 5 memberships. You guys are so generous. Thank you so very much. And Pepper also gifted a Watch the Obsession membership. Oh my gosh. So this week we are going to be doing a members only live. I know I said about this past week, but after I had the flu and then bronchitis and I just got back to work, as Nina knows, I have been so overwhelmed. I'm drowning in things I have to do. So yeah.
She gets to your email next week.
Yeah, something like that. I know. I'm sorry. I don't mean to be a jerk. I'm just.
No, I'm joking with you.
I know. Let's see. Oops. So, order serial length filings and all right. Do you want to read the state's motion regarding the neuropathological and psychiatric evidence?
Oh, they don't have it locked? Oh, wow, they don't.
Oh, I already downloaded it.
Oh, okay. Did you notice that all of the death penalties are gone?
Oh, really?
Yeah, off of the summary page, they're all gone.
Oh boy. You got those summary pages.
Yeah, I
though,
got a
right?
screenshot of it.
Nice. Good job. Yeah, that's what I have to do. I have to email myself the screenshots that you sent me to text. So do you mind reading this document?
No, I don't mind.
Okay. Are you going to read it from my screen?
No, well, I can read it. I've got it in front of me.
Okay,
If you
perfect.
want to put
Awesome.
it on screen, that's
Go ahead.
fine. But
You're good. Okay, cool. Awesome. Thank you very much. Oh, wait,
yeah,
hold
I'm
it.
blind.
I
I'm
put the wrong one
blind, so
up.
I will.
Hold it. I put the wrong one up. Let's see. The autism. Oh no, that was the right. I just changed the name of it. I'm sorry. I did have the right one. Here we go. Here we go. Putting it back up. Okay, girl, take it away.
All right. Comes now the state of Idaho by and through Latah County prosecuting attorney and respectfully moves the court for an order in limine prohibiting defendant from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant as summarized in the defendant's January the 23rd, 2025 supplemental response to request for discovery regarding expert witnesses. Specifically, the state objects to the proposed testimony of expert witnesses identified in defendant's exhibits D7 and D13, appended to defendant's supplemental response to request for discovery regarding expert witnesses. In support of this motion, the state respectfully refers the court to Idaho Code 18207, state's motion in limine RE neuropsychological and psychiatric, which provides that mental conditions shall not be a defense to any charge of criminal conduct, except expert evidence on the issues of any state of mind, which is an element of the offense. In each of the witness summaries, defendant exhibit D7 and D13, the defendant specifically states testimony is not intended to be a mental element defense pursuant to Idaho 18207, but rather this testimony is about state of mind as well as factual defense testimony to anticipated testimony elicited by the state. As such, this proposed testimony falls outside the mental condition evidence allowable under Idaho Code 18207. Yeah, you're going to put that in regular words, right?
Yeah, well, yeah, exactly. So hold it. So they basically don't want the neuropsychological evaluation expert and the results of, I guess, neuropsychological testing that Bryan Kohberger had done. They did not want that to be allowed. Okay. So let's see. Oh, case summary. Oh, this is the case summary. All right, I gotcha. Okay.
Now, see, I understand when they say that it can't be a defense, okay, because Idaho doesn't have insanity plea or anything like that, right?
Uh-huh. Right.
So they're saying that they can't bring it in as any kind of defense.
Right.
Correct?
Right.
Okay.
Right. So, and so then, okay, that's a good point because then it's a very touchy subject if you're going to bring it in at all. Because if you're not going to bring it in as a defense, then why would you bring it in at all? You know what I mean? So if it's not going to be if he's not using the fact that he might be on the autism Asperger's spectrum as a defense to the charges that he's facing, then it shouldn't be allowed as any kind of evidence or testimony in court at all, because what would be the point? The only thing that could do really would be to prejudice the jurors, make them feel bad for them, or, maybe they don't have a complete understanding of, what autism, what all that is, right? And oops, hold it, I'm trying to email myself this. So they're basically saying that, it just altogether does not need to be, the witness should not testify. It should not come into court as evidence, period, end of story.
But they can bring it in during mitigation.
Mitigation, yes. Mitigation's different. Yeah.
Right.
Yeah,
Right.
Good point. Yeah. That would be totally different.
Right.
Different, right? So, yeah. So I'm trying to send myself this stuff here. So, do you want to read? Are there any relevant comments in chat relevant to what we're talking about now? Nina? Oh, maybe she's not going. Maybe
Oh,
she-
I was reading them.
Oh, okay, I gotcha.
I keep myself muted because my dogs bark.
Oh, okay. What kind of dogs do you have?
I have one that is a red-nosed pit,
Okay.
one that is a Great Pyrenees Husky mix. She is
Aw.
huge.
Aw.
And then my 17-year-old boy, he's a Chihuahua mix. And then I've got a 15-year-old girl that she looks like a kangaroo. I don't know what she is.
That's cute. I used to have a red-nosed pit bull. His name was Bali.
You've got what, 29 bunnies?
Yeah, 29 bunnies. Yeah. Are there any comments related to what we're talking about here, honey? You know what I did? I cleared my cache or cache or however you say that today because I was just trying to get my computer running faster. And so normally when like I pull up something and I can just like click around, now I have to like put my password in it again, have to do my double authentication, all that stuff. So that's why it's taking me a second here. I apologize. All right, let's see. I'll make this bigger for you. Okay, so I've got these up anyway. Woo, these are really hard to see. It's okay. Let's see. Oh boy. Oh, good. I can scroll. All right. Okay, so I'm just going to go through these. This is a page of case summaries that did appear on that Idaho Court Cases of Interest website. And luckily, Nina got some screenshots of these because apparently they are not available anymore after that judge's order that just dropped just a little bit before this live stream. Must have been the very end of business today. Let's see. So the West Coast, they're 3 hours behind where I am here. So yeah, that was probably the case. Yeah, interesting. Super interesting. Oh, wait, let me download these because I don't want you guys to see my emails and stuff because I don't know what's on them. All right, there we go. Downloaded and open. And I hope everyone's having a good week and are looking forward to a good weekend. Is anyone doing anything? Anything good? Anything fun?
I'll be doing research.
You'll be doing research. You're good at it. Good. We like that. Let's see. All right, let me bring this in here. Okay. So again, this is the some summary. What's the summary that I'm bringing in here? The summary of what?
It's the case summary report.
Case summary report. Okay, cool. Okay, so we have because these are all dated February 24th, DB tape. Now I get it. Okay, so all of these little items that are summarized in the case summary report, thank you, Nina, those are temporarily sealed. So again, thank God Nina got these screenshots because you can't see them anymore. Oh my God, I'd be so pissed if I went to open these and they weren't there. So we have the motion in limine use of the term murder. Motion in limine. A motion in limine is deciding if that evidence is going to come in, essentially, right? If that's going to be allowed in court in the trial. I mean, in layman's terms. Motion in limine use of the terms psychopath or sociopath. So the defense doesn't want that. Motion in limine, Raylan Nowlin in reference to touch and contact DNA. Motion in limine number 7, witness identification and bushy eyebrows. By bushy eyebrows. Dylan. Motion in limine number 8, unnoticed 404B evidence. What's the 404B evidence? Do you know?
I don't have a clue.
Okay. All right. Keep reading. And then, motion in limine number 9, excluding Amazon click activity evidence at trial. I wonder why. Where were you clicking around, Brian? Where were you clicking around? We want to know. We want our alibi and where you're clicking around on Amazon. And then we have motion in limine number 10 regarding improper expert opinion testimony. Middleman. I don't know what that is. Motion in limine number 11 regarding exclude the IgG evidence. Get rid of all of it. We know you want that. And Brian. Motion in limine number 12. The make and model of the suspect vehicle. Okay. Well, oops. Let me just make sure you can hear me. I just hit the off button on my microphone. Okay, you can. And then we have down button. Motion in limine conditions as aggravator. Then we have motion to redact, seal, newly filed records, stipulated motion to defendants exhibit in support of their motions of limine under the seal. And then we have subject document motion to redact or seal newly filed record, term sociopath, same thing for click evidence, same thing. So these are just continuations of what we already went over. Whoops, now I got to go back to the other document. Okay, let me make this bigger and we'll go through this again. All right, so again, this is now sealed as an order from Judge Hippler went down just today to seal all of this February 24th, everything. So everything from the day February 24th, it was available to be viewed by the public on the Idaho Court Cases of Interest website. You can't see it anymore, but you can see it here. Okay, so February 24th, motion to redact or seal newly filed records, and that's inconclusive data and motion in limine, statistical analysis of something under seal, we don't know what. And then inconclusive data, statistic analysis. And then we have subject document motion to redact or seal the newly filed record, sealed stipulated agreement of the parties, not to mention 2014 cell phone incident during trial. Oh, when he stole his sister's cell phone. That's right. That's what that was, for heroin money. That's what that is. They don't want that coming into trial. All right. Let's see. And then there's a motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Okay. And then we have motion to strike the death penalty regarding autism spectrum disorder. Okay, motion to strike the death penalty. So once again, Ann Taylor is trying to get the death penalty taken off the table for her client. So this would come in at the mitigation phase, okay? Because it's, I believe, to strike the death penalty regarding autism spectrum disorder. So there is a witness that the state wants to the defense wants to testify that is going to say that Bryan Kohberger was evaluated and he is on the autism Asperger's spectrum. That is very clear. We didn't know that before. We know it now. And then there's a motion to redact or seal the newly filed records, stipulated motion to file defendant's exhibits in support of their motion to strike the death penalty regarding autism spectrum disorder under seal. And then there's another thing regarding autism spectrum disorder. So there's 3 different filings regarding autism spectrum disorder. And again, the state is saying they want to bring this up related to striking the death penalty. So do they want to just bring that in the mitigation phase, or are they going to try to also, get that allowed in per mitigation and then try to bring it into the trial as well? So this is where the state's motion from today comes in. Did you just read it or did I just read it? I can't even remember that. Is that freaking awful? We did, right? We did. So let me check out some comments here. Crime and Tides Welcome says the games the defense is playing, I wouldn't exactly say that law enforcement has conducted themselves with integrity, but the defense is playing games, not just doing their job and defending their client. Oh, that's a question. No, I think that I think Ann Taylor is doing a great job defending her client. She's doing the job that she needs to do. I mean, I think by virtue of the information and the evidence she has to work with, there has to necessarily be a little game playmanship in there. Oh, Anita, you come back up if you can. I'll put the link in chat again. I just noticed that you dropped down. Okay. Cuffy says, man, I wish this trial would start. This is excruciating, no doubt. What's the trial date now? It's slated to begin on August 11th, 2025. Jury selection will begin in the very end, I think it's last day of July. And I hope that's the case because I'm off in July and August, and I want to be able to cover this trial in full. Piper Bewitch says, hi, was looking up where he went after that day. where he went to Johnson, Idaho, maybe to get rid of things. Yeah, maybe won't surprise you. I have a video all about that. I think he actually needed this too. Didn't he return later that morning to the scene? Yeah, he did. He definitely did return later that morning to the scene. Let me just see if this was Nina texting me because she dropped off. Nope. Yeah, I don't know where she went. Okay. So, and we can talk about that as well if you would like to. So there was another state's motion. So we have state's motions for what I'm calling the three possible Bryan Kohberger defenses: the autism Asperger's spectrum defense, the alibi defense, and the alternative suspect defense. So another document that just dropped this past week. Oh, that was my bunny making noise. It scared me, obviously, you can tell. Is the state's motion in limine regarding the alternative perpetrator evidence. Evidence? Is there alternative perpetrator evidence? I don't know. Comes now the state of Idaho by and through the Latah County prosecuting. This is just legalese. So they're citing state versus self. And the Idaho Supreme Court stated in that case, let's just get to the gist of their rulings. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will be subject to the limitation provisions. So it says, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of the information regarding the defendant, none of the tips were substantiated. So, The state submits that any attempts by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting persons other than defendant to the homicides would do nothing more than to mislead and confuse the jury, and would also result in undue delay, a waste of time, would be a needless presentation of cumulative evidence, and unfairly prejudice the state. Under the Idaho Supreme Court's ruling in Meister, this should be prohibited. So again, so who could the alternate suspects be? So the state knows, I would say knows, because I don't think they would file a motion simply on a hunch that, Bryan Kohberger is going to put forth an alternative suspect defense. So they must know that that's on the way. So who could the alternative suspects be? Maybe Jack DeCore, possibly? Hey, Jack DeCore? What do you think?
No.
Who do you think would be their alternate suspect? Or would it be the actual people that belong to the DNA, the glove and the banister, the handrail DNA? I don't know. Who do you think their alternative suspect theories would point to?
I don't really think that. I think that he's putting that out there just in case, but I really do not see her doing that.
Emotion based on just in case. That's the thing.
That's what but I don't see her going with the drug theory. I don't know. She could.
That's so convoluted. There's no evidence, I don't think, towards
but
that.
That's what I'm saying. There's not, with the type of person that she has shown to be as far as an attorney, for her to put an alternative out there would have to be something that she could really bite into. And I don't see it.
Well, the fact that the state filed a motion, like not wanting to allow this in, she would have had to have put something forth, or this motion would be superfluous and a waste of the court's time. We know how Judge Flipper feels about that. So something must have been indicated towards an alternative suspect.
Well, have I missed it? Have they put in any kind of alternative?
Well, so much is sealed, we might not know. Or something, Yeah.
This is true.
So, because I think if there is a motion stating that, then we would, she would have had to put something, something came up, something was already put forth by the defense indicating that they are considering or, putting forth an alternative suspect theory, which is kind of crazy, but I mean, that has to be the case or the motion would not be filed, especially with Judge Hippler. Oh my God. He'd be pissed.
He would be going to ride his Harley.
Yeah. Right? No, I don't think so. Oh my gosh. Let's see. Oops. So do you have in the unsealed transcript, the part about Dylan and the person going up and down the stairs? Do you happen to have that you can read? I'm looking for it here.
Yeah, let me see if I can find it.
Yeah, let's see. Is she? Let's see. Oh, I know. I'll search stairs. That'll work.
Oh, well, that was smarter.
Okay, I found it. It's on page. Let's see. Where does it start here?
Is Deb Tape still in here?
Are you still in here, Deb? Let's see.
Now, I mean, I don't know though. With the other two DNAs, that could definitely give her the. I mean, because that makes you question anything. I mean, even the side I'm on, it makes you go, wait a minute. I'd go ahead and test them just to say this is who it is, and it's not allowed or whatever. But then somebody sent me the CODIS, all the requirements and everything for CODIS. And sure enough, I mean, if they've got the DNA from the knife sheath underneath the victim, they consider that like the number one,
right?
Suspect.
Right, because you can only submit one sample of suspect DNA to CODIS at a time, and IgG goes along with that same guideline. So, the defense is saying, oh, well, there was this DNA on the handrail and this DNA on a glove outside. Well, they could only test one sample. They could only submit one sample. So obviously the sample that's going to be submit is going to be the sample of the knife sheath that fits what the medical examiner determined was the murder weapon, partially underneath one of the victim's bodies and upon the bed where two of the victim's deceased bodies reside. Obviously, right. That's going to be the DNA that's tested.
Well, see, and that's the way I look at it too. And I mean, with the being on the first floor hand railing, from what I understand, he never did even go to the first floor.
Right. I mean, we don't know for sure, but it does seem that way, right? It definitely does seem that way.
Now, what are we hunting?
Okay, I found it here. Oh. So I'll just read it here. So it says, let's see. All right. So I'm just going to pick up. It's just embedded in part of this unsealed transcript here, but it's interesting and it's a little more now that we know about what Dylan Mortensen said or saw. Okay. So, all right. She's one of the roommates. Is that right? And the court says, we're sealed. You can use the name. And Miss Taylor says, I can use the name, trying to get a habit. Question, redacted. Dylan Mortensen, who is she? Answer. And this is Detective Balance, right? I think it's Detective Balance, or is it?
Yes, I think that's.
Okay,
I think that's.
Okay. She was one of the surviving roommates. Question from Ann Taylor: how many times was Dylan Mortensen interviewed by law enforcement at the time you wrote the December 23rd report? Officer Balance says, if memory serves, it was 4. I think 3 or 4. Ann Taylor, in the affidavit, you wrote a statement that she heard Kaylee go upstairs, yell, someone's here, and run back downstairs. Is that correct? Yes, ma'am. And you used the word she thought she heard. Do you remember that? Miss Jennings then says, Your Honor, I'm going to object. I'm objecting based on the scope of what this testimony is supposed to be. My understanding is that it was limited to IGG. The court says, I was just about to ask the question. I don't recall the statements of Dylan Mortensen being a subject of the motion to suppress, separate from the Franks issue. Am I correct about that? Ms. Taylor says, that is correct, Your Honor. Court says, okay, so we're not at a Franks hearing on that issue. The only issue we are at a Franks hearing on is the IGG. And then Ann Taylor says, all right, well, let me rephrase. Let me start from a different place. So then she talks about Bryan Kohberger's AT&T records, and then, you know, everything that they're going to talk about at the with having to do with the IGG. But apparently what was said by Dylan Mortensen was that she heard Kaylee go upstairs, yell someone's here, and run back downstairs. Well, it is Ann Taylor herself who makes the proper point that Dylan Mortensen said, you know, I wasn't sure what was a dream or if I was awake or like what was reality or not. And that could be a result of her intoxication, her being hungover, or just the trauma of what she was going through and the confusion. You know, if what she said was she heard Kaylee run up the stairs, say there's someone here, run back downstairs. If she's a little iffy on the details of what happened for those reasons, couldn't just as easily Kaylee have run downstairs, say someone's here, and then run back upstairs to where she met her horrible fate? You know, so it's almost like I feel as though she's almost, you know, cutting down her own point in a way.
She's definitely taking away from it.
Yeah, yeah. So,
but I mean, you know, considering the shock and everything, I mean, I can't even imagine that kind of shock.
No. Oh, no.
Especially being 20 years old.
Absolutely. Yeah. I totally agree. I feel terrible for her. I always have. I mean, she just, you know. So what else? Is there anything else that we haven't talked about yet that you found to be outstanding, that we should be discussing in the recent documents?
You mean besides that autism thing?
Yeah.
You mean the big elephant in the room?
Right.
Because I want to hear from you, because I did not know that you were an expert in that. I have so many questions.
Well, you go ahead and ask those questions. But, you know, when I told you that earlier, I hadn't realized that in the summary, they explicitly stated something about autism spectrum disorder. I thought that you were possibly gleaning that from doing research about the neuropsychological evaluations, where that is the expert that the state does not want to testify. So I know the only reason somebody would have a neuropsychological evaluation is for you know, either a cognitive disorder, a learning ability, or something of that nature. So that it's going to be a learning disability, it's going to be autism spectrum disorder, or, you know, a cognitive impairment, which would go into more of the level of like what we used to call like retardation, which, by the way, before anyone gets mad at me, is still a term that is used today in the profession. So those are the only three things that would cover. So the neuropsychological evaluation, without knowing that they explicitly mentioned autism spectrum disorder, told me that that's what they had to be going for, either that or a learning disorder. But we now know.
Okay. So with you saying that, so then here comes the all these that got struck today about the autism spectrum disorder. So they've all got struck off and sealed and everything, but they left on there the state's motion for the neuropsychological. So if they leave that on there, then everybody's still going to know what's going on.
Well, I don't know if everybody. I know what's going on because that's my profession. But I mean, people like me are going to know that, and they're going to talk about it like I was planning to, not knowing that, you know, they explicitly mentioned autism spectrum disorder. So yeah.
Oh yeah, I mean, because you saw there, I mean, it was right there. It's and it says to strike the death penalty.
Right.
I mean, so. I mean, I can't believe. I guess to me, I would have struck the state's motion too, if I wanted to keep it completely quiet.
Yeah, but we don't know the reasons for, we don't know the reasons why he put that order in at the last minute today. We don't know what the reasons are. So it
Probably
might
because their body was going crazy.
Oh yeah, maybe, possibly.
I don't know. He probably doesn't watch YouTube.
No. I mean,
I
I think
mean,
he'd keep his finger on the pulse of things, but I don't know if he would have been. I don't know. What do you guys think in chat? Do you guys have any thoughts?
I wonder if those were even supposed to have shown up on the summary, or if they were supposed to have been like sealed before even getting on the summary.
That's very possible. That is very possible. I was surprised when I actually saw that in black and white. It's not.
That's the reason I took a screenshot. I was like, it's going to disappear.
Yeah, no, I'm so glad you did. My God, that was awesome. Good job. Yeah, and it did.
I mean, because it was just all of a sudden. I mean, it was like, and I mean, I can see just from the research I've done, I can see some of the, even though he has a PhD and everything, I mean, I don't see it as a learning disability, but I mean, there's so many different kinds of learning disabilities.
I don't think I'm going to make a statement here, and please don't anyone get mad at me. I understand the range and the difference in everybody's an individual, but listen, it is so rare for somebody with a true diagnosed learning disability to get to a PhD level. It's autism spectrum disorder, though. Yes, that will happen. Yes, it's different. So
because can't they be?
Autism is not a learning disability. It is not. It's classified, like if a student has an IEP, they have a learning disability. Some will have learning disability. Some will have, and then autism is not called learning disability. It's just called other health impairment because it is not a learning disability. So just understand that, a lot of people who are on the autism spectrum are exceptionally intelligent or, in certain ways. A lot of you know that. So
well, it is protected in Idaho.
It is, yeah.
Yes.
It is.
Yeah. It like as far as the death penalty goes and everything is one of them listed as far as like protected from it,
Huh. Let me bring in I was watching this earlier. It's Crime Fix because there's a defense attorney that talks specifically about this. Here, let's see. I'm gonna just bring this in here.
Also result in undue delay, waste of time, would be a needless presentation of cumulative evidence and unfairly prejudice the state. Under the Idaho Supreme Court's ruling in Meister, this should be prohibited. The prosecution is also asking Judge Hippler to bar the defense from presenting their alibi at trial. The one where he was out driving west of Moscow, including visiting Wawawe Park. The prosecutor writes, the defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi, as directed by the February 23, 2024 order setting deadlines and hearing, and as discussed in the state's April 26, 2024 response to notice of defendant's supplemental response to state's alibi demand. So there is a lot to talk about. And to do that, I want to bring in Philip Dubé. He has worked as court-appointed counsel in Los Angeles County. Philip, there have been a lot of motions in limine filed to address issues at trial. And I want to start with this first one about the state basically saying Bryan Kohberger's this alibi he's presenting that he's at this park and he's driving around, not really an alibi. And so Judge Hippler should tell them they can't present this at trial. Your thoughts on this?
Well, it's a little complicated, and I'll tell you. Obviously, he wants the jury to know that he was elsewhere at the time of the crime, that he was either praying and chanting and sitting in a lotus position, maybe doing Pilates stretches, looking at the stars, as opposed to slitting poor students' throats, okay? And that might be true. Let's give him that. The problem is you have to disclose that upon a discovery request from the prosecution early. You can't just wait to the 11th hour. And there are reciprocal rules of discovery in the state of Idaho that require the defense to turn over all the facts surrounding the alibi, any witnesses who can corroborate it, any physical or circumstantial evidence or digital evidence that you might have. If you don't turn it over, it deprives the state of its ability to investigate it and to rebut it. The remedy is discretionary exclusion by the judge. So in theory, Judge Hippler could just say, you know what, you didn't turn this over, knock off this gamesmanship. There is now a doomsday sanction for this type of gamesmanship, and that is exclusion. So move on to your next defense theory. It's not going to be alibi. Now, on the other hand, you never want to deprive a defendant of a defense. And it is discretionary for a reason. There may be legitimate, good cause reasons why the defense did not turn it over. It could be that they were waiting for the prosecution to provide them with really important probative evidence to prove his whereabouts that they could not get on their own through the subpoena power. And it could be that the prosecution was dilatory or lollygagging and not getting it to the defense to show that he in fact has an alibi. But if that is the case, the prosecution had it all along. So they really can't cry foul if the very evidence that they need to refute the alibi was already in their possession.
Well, the defense has accused the state many times of multiple discovery violations. They want to strike the death penalty because of that again. So they've made many of these arguments. But they're saying, the state is saying, look, you missed your deadline and you haven't given us any witnesses. You haven't met the code requirements for presenting an alibi. So Hippler seems like he doesn't really put up with any type of, nonsense. So do you see him saying, basically put up or shut up to the defense, hand over the witnesses if you have them?
I think what the court's going to do, and it's very common, the court's going to set what we call a compliance date. In other words, make an order saying, look, I'm not going to exclude it, but I'm going to give you a drop dead deadline. If you do not meet that deadline that I am telling you now, you're not going to put on that defense. So what he's going to do is give them a date. And then that date is always subject to a good cause continuance if for whatever reason they cannot turn it over. And it goes back to what I just said a moment ago, and that is they could be waiting for discovery from the prosecution to help buttress their alibi defense. And you just put it all out there on the record, and the judge can factor that in. But there is no way on God's green earth that the judge is going to exclude alibi. At most, he just might put the trial over, give them a little more time so that everybody is on equal footing in presenting the case.
Let's move on now to the barring of the some other dude did it defense. The state is saying they shouldn't be allowed to point the finger at a third party, other suspects, unless they meet certain requirements under Idaho case law. And they mentioned the Meister case. Are they doing this in part because of this unknown male DNA? I mean, I feel like this is pretty common. I've seen this in other cases where prosecutors say they shouldn't be allowed to point the finger at other people unless they have evidence of it. But does this have something to do with those unknown male DNA profiles that the defense has brought up in court time and time again?
I'm sure that's what it is, because that's the only evidence that they have that somebody else might have been at that house. And to be fair, it really could be an alternative type perpetrator of the crime. But again, it goes back to what I just said moments ago. They already have that discovery. Remember, the defense learned of it through the prosecution. So it should come as no surprise and no shock that they're going to try to use that biological evidence to link this sort of unknown third-party culprit to the homicide. Now, the problem is for the defense, if you really think about it, it's sort of inconsistent. He's saying he was sitting in the lotus position, contemplating his navel, looking at the stars. Okay. How can you have an alibi? Okay.
Oops. Darn it.
And yet claim that there is a third party culprit.
Sorry, this guy is so funny. I just had to say that.
You have to kind of pick your poison, if you will. Otherwise, you're going to have to put on both defenses, and it's going to look desperate to the jury. The problem with third-party culprit or alternative type perpetrators is that you have to have more evidence than just the means, the motive, and the opportunity for this unknown third party to have committed it. You need something concrete to really link that person to the crime, as opposed to just some evidence of presence of another person's DNA in the abstract. And what they should do, maybe, if they haven't already, is run that specimen through CODIS, the Combined DNA Index, or through investigative genealogy, like they did to Bryan Kohberger, and see if you can find out who that is. If you're not going to do that, then it looks like the state's hiding the ball. Because I don't believe that the defense has the capability of just presenting a specimen to private data banks and asking them to do an IgG run. They can't do it because it's law enforcement activity in nature, and the defense has no standing or contractual right to do it.
Yeah, there's been conflicting answers given about the unknown male DNA. The prosecution said in some court filings over a year ago and in court that there weren't enough points or whatever, it wasn't suitable to upload to CODIS. And then the detective said at a recent hearing, we couldn't pull, the unknown, which turned out to be Kohberger's DNA, they're saying, on the knife sheath. We couldn't pull that out of CODIS and then insert these other ones. So there's been two kind of conflicting.
And that's what we were talking about earlier, Nina, that you can't, you can't say, oh yeah, I've got 10 DNA samples here. I want to upload all of them to CODIS and let's run all these through IgG. It just doesn't work that way.
People got to consider too the financial part of it.
Well, also, that would also open up, the possibility of, identifying, blaming, charging, prosecuting, and sentencing totally innocent people. The DNA that you're testing needs to be material linked to the fucking crime. And that's why the DNA on the knife sheath that held the kind of weapon that the medical examiner determined the injuries of all four victims were caused with, that was laying partially underneath one of the victims' bodies and on top of the bed upon which two of the victims' deceased bodies laid, that was the obvious DNA sample they were going to test. Obvious. And to me, that ends that argument right there. All this IgG, blah, 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 blah. It's just crazy. I mean, I know Ann Taylor has to do this. She's defending someone against a freaking firing squad, which is so barbaric, but I guess all death penalty is really, it's just kind of crazy. Here, let me keep playing this guy and then we'll come back to talk.
Accounts of how that went down. But yeah, IgG, they could do that and figure out who these people are and then go interview them. And then there you go. Exactly. That takes care of that.
Exactly.
This 3D model thing that they want to bring in, this defense agreed to tear the house down. They said, we don't need it. State says we don't need the house. There was a big hullabaloo.
Oh, that was one of the motions we haven't talked about yet.
About tearing down the King Road house before trial. Now the state wants that they said the FBI is making a 3D model. They can take it apart and show people where things happen in the house. It's a wonky shaped house. Do you think the defense objects to this?
I don't think so, to be honest with you, because if you really think about it, let's just pretend that the house was still standing. In theory, the prosecution could have moved for what's called a jury viewing. And in theory, the judge could have allowed the.
I just have to say, guys, I'm going to turn off the chat replay. You guys, and you wouldn't know this. So I just want you to know, though, you shouldn't be sharing your email and chat here because the chat replay is usually available. And that opens you up to all kinds of financial, now, if you need to exchange emails, you can send them to me and I will do my best to coordinate them the way that you wish. But I just don't want you guys to have anything bad happen.
The jury to actually go out to the scene, but I doubt that the court would have done that. Instead, the court might have said, well, look, what else do you have that's a reasonable facsimile of that house? Do you have video, for example? Do you have a model of the home? What else do you have? Well, they're bringing in the next best thing, and that is basically a playhouse, if you will, of that.
Sounds like a dollhouse.
That haunted house, like a dollhouse, exactly. Albeit a little Alice in Wonderland-ish because it's miniaturized. But nonetheless, if it sort of meets the specs of the size and the dimensions of all the rooms in that house, I think it's the next best evidence.
I want to get to the big one now. The state is going back to the death penalty. Okay. They are saying now, and I don't know why they didn't bring this up before, that they want to strike
Here you go, Nina.
the death penalty. And they're citing autism spectrum disorder, which includes Asperger's syndrome. And I bring that up because Bryan Kohberger, from the little bit we've seen, if he's on the autism spectrum, I would think it would be at the very high functioning end. What do you make of this? Because the exhibits that are attached to this motion are sealed. Gosh, like, is this a last ditch effort to strike the death penalty? I mean, I'm thinking Asperger's only because that is on the higher functioning end of this. And he's a TA, and it talks about social awkwardness, having trouble maintaining relationships, things like that. Those are hallmarks of Asperger's syndrome.
Yeah. Well, first of all, the U.S. Supreme Court held back in, I think it was 2002, in a case called Atkins versus Virginia, that states cannot execute the intellectually disabled, period. So what it would do, and I don't know that I would necessarily call it a last-ditch effort, it's basically what I call a process of accretion in litigating a case, and particularly a capital case. You start with your initial line of attack, and that was get all the evidence, look at it, and see if any of it is inadmissible, and then you file your necessary suppression motions, where the evidence can't come in on constitutional grounds. And unfortunately, the defense suffered all kinds of defeats on that front. So now what do? Well, now you're focusing more on penalty. And if you can invoke your rights under Atkins, then you request what's called an Atkins hearing. And that is a hearing where a judge actually takes testimony from all the experts and decides whether or not the capital defendant meets the criteria of being intellectually disabled. And essentially what the defense has to show is that he has a sub-average IQ, and it's typically way below 70. And in fact, in the Atkins case, I think Mr. Atkins, who was 18, had an IQ of 59. I mean, he was mildly mentally retarded. And I don't even know if it's politically correct to even use that expression anymore. But back in the
No, honey, I already told you. That's what we use, and that's what we use in the professional field. It's okay. You got to just not be an asshole about it.
those days, that was the operative sort of clinical language that they used. And then you have to show that they have poor performance and social and adaptive and behavioral skills. And you also have to show that these deficiencies probably were exhibited before the age of 18, because you have to show that this was like a lifelong battle and not something that you're just going to discover or manufacture in your adult years to skirt the death penalty, if you will. So now what it is, it's a question for the court, and it's litigated at the Atkins hearing. And for now, the motion is impounded or sealed because there's certain, I don't want to say proprietary, but private confidential opinions that were rendered probably by various neuropsychologists who may have done some testing, psychiatrists, and then regular clinical psychologists. So you keep that kind of non-public until the hearing.
This other motion that's been filed is pretty interesting to me too, because I don't know if I've ever, maybe I have heard actually. I've covered a lot of cases, and I've seen some prosecutors say some things over the years that were somewhat inflammatory. But the defense has filed a motion about the use of the word sociopath or psychopath at the trial. They don't want that either of those terms used. You know, a psychopath is clinically somebody with no conscience, and sociopath is kind of like a brother of that or a cousin of that. So, wow, why would they file that? Because that to me seems like something that might come in.
Sort of, but not exactly. A psychopath is born that way. There's something inherently wrong with their brains, and they have no conscience. A sociopath is socialized to have that similar looking pathology. So I guess to call it a cousin of sociopathy, a cousin of psychopathology, is sort of correct, but I just wanted to give you more definition on that, y'all, because this is what's the obsession, and that's what we do.
And maybe in a penalty phase, if you're talking about possible testimony from a psychiatric expert or a psychological expert, it's certainly not, to me, something that would come in your case in chief.
Well, every state has a definition for the parties to a criminal action. In other words, the defendant, the plaintiff, which is usually the state or the people of the state, and then certainly the victims and the witnesses, and they all have definitions. The definition of a defendant is not a psychopath. It is not a sociopath. If you go beyond the legal definition of the named parties, it can be very prejudicial. If you keep referring to Bryan Kohberger as a psychopath when he is presumed innocent, rather than the generic title given to him by the legislature, just by virtue of being accused, it tends to tilt the balance, if you will, in favor of guilt before you've even heard one shred of evidence. So I think it's inappropriate. It's unethical. Just like you don't refer to victims as a defense attorney as liars, as money grabbers, as people out for their own interests. They are victims, they are witnesses, and you let a jury decide. Now, in closing, it might be fair comment by weaving in all of the evidence that was presented at the trial in characterizing the parties and the witnesses based on what is in evidence. And if that's the case, then at least it's not, I don't want to say inflammatory, but it's certainly not unethical. It's only unethical if you comment outside the record or if you comment on anything that has been excluded by the court. I think it's fair game to sanitize it, keep the parties' names to what they are referred to in law rather than what you want to refer to them in social settings, if you will. And we are in a legal setting, and I think it would be very prejudicial to refer to him as a psychopath.
I agree.
Yeah, most definitely. Well, we'll see how it all plays out. The defense is also looking to exclude that IgG evidence, the genetic genealogy DNA evidence. Again.
Never.
Yeah, it's interesting. There's a lot going on, and they've actually brought their DNA expert, Bricka Barlow, on as counsel now. So It's very interesting stuff. Philip Dubé, thank you so much for your time as always.
Have a great day.
And that's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much for being with me. I'll see you back here next time.
You know what? I think they did a good coverage of that. I'm going to go back to the beginning.
Ethan Chapin and Xana Kernodle. He tried once to have the death penalty removed as a possible punishment. Here's his attorney, Ann Taylor, last year.
The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. Idaho brings it back in 2023. They bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall, from the media at least, that the construction's actually underway, but I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from at that.
Oh, damn. She just smacked down the judge. The judge is like, oh, I've heard it's in building from the media. She's like, well, I would talk to the expert judge. Middle finger to you.
She forgot who she was talking to.
That's right.
Additional problems with the
Judge
firing
Hippler,
squad.
not Judge,
No.
baby.
I think there's some problems with the way our statute lays it out too.
Judge Hippler denied the request to strike the death penalty, and that wasn't a surprise. But now the defense is taking another swing at striking the death penalty. The defense has filed a motion to strike the death penalty, citing autism spectrum disorder. But the exhibits attached to the motion are sealed, like many of the other documents in the case. Now, this is the first time we've heard anything about Bryan Kohberger possibly being on the autism spectrum, which includes Asperger's syndrome. The defense is also asking for permission to file other motions to strike the death penalty. So they're not giving up this fight, not by a long shot. And get this, prosecutors are asking to bar the defense from presenting neuropsychological and psychiatric evidence. Now, a lot of the documents, as I mentioned, are sealed in this case, but the prosecution says they're doing this in response to witnesses the defense wants to call. Remember, Idaho doesn't have an insanity defense. Prosecutors cite a statute which provides that mental condition shall not be a defense to any charge of criminal conduct, except expert evidence on the issues of any state of mind, which is an element of the case. Now, pretty interesting, because the defense apparently wants to call those witnesses into response to witnesses the prosecutors want to call. The defense had written, testimony is not intended to be a mental element defense pursuant to Idaho Code 18-207, but rather this testimony is about state of mind as well as factual defense testimony to anticipated testimony elicited by the state. Now, I think this may have to do with testimony that prosecutors want to present about what was going on with Bryan Kohberger in his life at the time that these murders were committed. There have been reports that things were not going well for him with his teaching assistant position at Washington State University. We'll see at trial. But another thing that caught my eye, the defense has filed a motion asking the judge to bar the use of the word psychopath or sociopath at trial. That might come in during the penalty phase. More on that later. Now, remember when the house on King Road was torn down? Haley Gonsalves's family was incredibly upset. They were worried that it would be needed for trial and that the home was torn down prematurely. But the defense and the prosecution both agreed the house would not be needed for trial and signed off on the university tearing the house down. So the house came down in December of 2023. The house had a really odd layout. So prosecutors are asking the judge to allow them to show the jury a 3D model of the house. They write, this model will consist of 3 levels, which can be removed by level to show the interior layout of the residence. The interior layout will depict wall and doors placements, i.e. no furniture, human depictions, etc. The model will be placed on a rolling table for portability within the courtroom, can be placed out of the way when not in use. This model is being constructed by the Federal Bureau of Investigation based on depictions, documentation, and measurements taken at the scene prior to demolition of the 1122 King Road residence. Now remember, the feds had gone back to the house to measure it. Prosecutors continue. The primary purpose of this model is to aid the jury in having a better understanding of the layout of the residence, which is unconventional, and to illustrate where certain events occurred within the residence. The model will aid certain witnesses, i.e. law enforcement, surviving roommates, individuals responding to the crime scene, and crime scene analysts in demonstrating the location of victims, location of witnesses, location of items of evidence, items related to their testimony, path of travel, etc. The state anticipates laying the proper foundation to establish the model accurately reflects the layout of the 1122 King Road residence. The world can be a really scary and unpredictable place, and that's why having a great lawyer really matters. And that's where Morgan & Morgan comes in. The firm has more than 1,000.
Right. Okay. So anyway, so that was just a reintroduction of everything we talked about. So I don't know. I think I'm going to wrap it up. We're surprisingly already almost going on 2 hours here. Let me just see a couple comments in chat, and if there's anything you want to say to end, Nina. Yeah.
Well, I mean, oh man. There's so much to say, but then there's not anything to say because you don't have anything to put with it.
Yeah, exactly.
I mean, you know what I'm saying? I mean, I'm not one to just come on a panel and just say blah, 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 because I want to say it. I mean, and with them striking everything and sealing everything, I mean, they just put that it was like, here's the candy, but you can't have it.
Yeah, I know. It's kind of weird, but yeah. So, well, and I also just want, I want people to definitely go over and check out your channel. You got a lot of great content on there on the Idaho case. I mean, are there any other topics you guys want to go over? I mean, I have content literally made on every single thing in this case.
See, and that's the thing about it is, I mean, that's one thing that I respect about you and some other creators is you don't just do it just to put it out there. You know, if it's not something that needs to be out there, and and that I guess that's where I took mine from was, I don't want to be just a one case creator.
Yeah, no.
Does that make sense?
Yeah. Oh, yeah. Watch the Obsession. Hello.
But I mean, see, when I first started, I did a 4-part series on the Angie Dodge murders, but it was about her murders, but it was mainly about Chris Tapp. And the reason I did that was because to me, it was sort of going along with the Idaho 4 because, the IGG exonerated Chris Tapp.
Right. Oh, absolutely. Yeah. No,
And
interesting. That's cool.
But they didn't. I mean, it was like, I don't know what it is, but if it's not Idaho 4, it's like, what case? I've never heard of that.
Yeah, no, I know. Well, I mean, it's really, it's a really in-depth case and you're interested and you do a good job covering it. So yeah, that's okay. There's nothing wrong with that. So yeah, everybody definitely go check out Warning Label, Nina's channel. The link is in chat. And I think I am going to end this because I've just got, I've been getting over getting sick. So I've got to get some good sleep tonight. But I thank you guys all for being here. Thank you so much for coming on and for helping me find this information. I would have been able to sort through it all without you again. So
Well,
thank you so much.
I'll be texting you if anything happens.
No, thank you. I appreciate it. And thank you, moderators. You guys are the best. I'll be texting y'all soon. And members, subscribers, and people just checking us out, come down out of the rafters and say hello. John McSmith. And thank you, Sherry, Honeybun, and Pepper for the super chats and memberships, gifted memberships to others. Hey, Sabrosa, how are you doing? I appreciate all you guys. And I've just dropped a few new videos on some different cases. So definitely go check that out. Love y'all. Please be nice to one another because life is hard, but most of all, be good to yourself because you deserve it. Yeah, you do. We love you. All right.
Thank you.
Thank you, Nina. Take care. Bye-bye.